Hello, I'm John Combs. I'm a securities entertainment attorney in the sense that I do securities compliance work for independent film offerings, both features and documentaries. Been doing it for about 35 years. I'm not going to go into too much detail on my background because the full bio is available at my website, Film Finance Attorney, right here, and along with articles and lists of films that my clients have done over the years. Um, about 70 films, not a big number, but still, it can be done. And I'm going to talk about briefly about two of those. One on the low end, the range for the films that I've done that have been successfully funded goes from 100,000 on the low end to 10 million on the high end. The Letters was the $10 million film. That was Bill Reed's film. He used to do the um, how the films were made, kind of movies for the major studios, and decided to do his own project. And he raised about 10 million. Took him several years to do that, but he ended up with a beautiful film. I saw the premiere at DGA Theater in Hollywood, and it's really a beautiful film. So I recommend it. The other one on the low end, we did $120,000 offering. A young man who just at that time had just graduated from UCLA Film School, and he wrote the script, wanted to direct and produce, put together a little ensemble cast, did the film, got it into Sundance, didn't win any awards, but got a deal, theatrical release deal, and an advance of $1 million. So he and his investors were in profit before the film was even in release, which of course is the ideal for independent filmmakers. Doesn't happen often, but it can be done. And that's another little film a clever little film, a script that you might want to check out. The name of that producer, director, writer was Justin Lin. Many of you are familiar with Justin's background. He's directed some of the Fast and Furious and some other films of consequence. And there's my contact information down at the bottom. See if I can use that laser again. And I am always happy to talk to independent filmmakers who are threatening to make a film. So feel free to call if you have any questions about this material, and or send me an email. Also, it may not be necessary to take copious notes on this presentation, because if you call me or email me and ask me, I'll send you the outline for the presentation, so you'll have most of that. So it'll take some of the pressure off. Just sit back and enjoy. So we'll move on to the next slide. One of the things that prompted me to do this was that from time to time I'll cast about, look around, and see what other people are saying about film finance. I wrote the book 43 Ways to Finance a Feature Film. My most recent book was Investor Financing of Independent Film. I wrote the Dictionary of Film Finance and Distribution Terms, amongst the 20 books that I've done over the years. Most of them are how-to books, and most of them about film finance. Some of them are critical of the film industry or historical in that sense. But anyway, I went on YouTube and I put in film finance, and just to see what other people were saying. There were about half a dozen or so videos there. Some of them very short and not a lot of information, but some of them were somewhat credible. Um, the one thing, and this was interesting, the one thing that all these presenters on the YouTube film finance videos agreed about was that most low budget independent films are investor financed. So most low budget independent films are investor financed. Now, one of them went so far as to say that 99% of low budget independent films are investor financed. That's not really accurate. Nobody knows that for sure. Nobody sits down and calls 2,000 independent filmmakers every year to ask them how they finance their feature film. If they did, they'd probably be told it's none of their business. But uh, the statement that most low budget independent films are investor financed, I agree with. Most of these presenters agree. And so I think we can safely say that is true. Now, what they don't tell you in these posts, and they don't teach you in film school, is that most investor offerings involve the sale of a security. There's a lot of misinformation out there in the marketplace, in and around Hollywood and in the film business about this issue. But most low budget independent films are investor financed. Most investor offerings involve the sale of a security. Okay. Now, here's another statement that I think is true. Most independent producers probably don't know that they're selling a security. It's often the case that they don't know. And I would submit to you that it is not likely that a filmmaker would be able to comply with the securities laws if they're not aware that they're selling a security. You follow my logic? So the other thing is that none of these film finance experts, and they're not really experts, but they do have some level of expertise, but none of them in these presentations on YouTube relating to film finance even mention the need for securities compliance. And that's an important omission, in my opinion. Uh, so we'll move to the next slide. And I say that just in case your computer for some reason doesn't advance the slides automatically. So that leaves us with this question: what is a security? And one of the most important things we're doing today is helping you determine and have some confidence in knowing when you're selling a security and when you're not selling a security. So remember that most of these investor offerings of low budget independent films do involve sale of security. So it's important. And there's some important consequences or significant consequences for not complying with securities laws. And we'll talk about that a little bit later. Fortunately, the federal government has provided us with a definition of what is a security. It's in a statute. You know, Congress used to pass statutes. I'm joking. But the federal definition, and unfortunately, it's just a listing of various financial transactions that are considered to be securities. So it's not really an adequate definition. But it does mention two that we're going to talk about. One is a profit participation agreement. The other is the investment contract. Those are amongst other financial instruments or transactions that are considered securities. Nobody's really defined what a profit participation agreement is. None of the cases do. But they do define, so I'm not going to talk about that much. They do define the term investment contract. In fact, one case went all the way to the Supreme Court, and that is this Howey case, what we call the Howey case, SEC versus W.J. Howey Company. And basically, they came down and said, okay, there are really four elements to an investment contract, which is a security. Okay, an investment contract. One, there's an investment of money. Of course, it's an investment of money. Investors, that's what investors do. They invest money. There's a common enterprise. In this case, it's a film producer and a group of investors. So there's a common enterprise. They're in business together. And there's an expectation of profits, both for the investors and the producer, hopefully. And the profits are supposed to be derived primarily from the efforts of others, which is another way of saying the investors are passive, not active. They're not actively involved in helping make important decisions. So those are the four elements. Now, when I first started lecturing about film finance in Los Angeles, I was there for 23 years. I got a lot of questions about this kind of definition, and a lot of independent producers had a little bit of difficulty processing the four elements, so to speak. So I made an effort to come up with something that was simpler, that really summarized these four elements. And that effort led to the idea that there is a distinction between active investors and passive investors. Now, I later learned when I was writing an article for Los Angeles Lawyer magazine that was published, that now has been incorporated in my book, Investor Financing of Independent Film. I learned that there is case law support. In other words, there are some cases that support this distinction between active and passive investors. Passive investors involves sale of security. Active investors does not. So it's really important that you know when you're dealing with active investors and when you're dealing with passive investors. Okay, so we'll talk about that in a minute. That's an important distinction. And the case, as I say, the case law supports. I'm not giving you citations here, but citations are included in the articles that are in the investor financing book, investor financing independent film book. And so you can actually look it up. So we'll move to the next slide. We'll define active investor, because what is a passive investor? they're not active. That's pretty simple. We can deal with that. What is a passive investor? They're not an active investor. So let's define active investor as the courts. This is what the federal courts say an active investor should be. They should be someone with sufficient knowledge and experience in the relevant field. These laws apply to all industries, not just the film industry, but someone with sufficient knowledge and experience in the relevant field, in this case, the film industry, that allows them to play a meaningful role in helping to make important decisions associated with the project. They don't have to have veto power, but they have to have the background and the knowledge, experience that allows them to play a meaningful role in helping to make important decisions associated with the project, and they actually participate in that decision making. In other words, you can't say they're active, but not let them be active. So you have to be willing to allow them to participate in the decision making process. And the best practice, if you're going to go this route, the active investor route, non-securities route, is to document their participation. In other words, create a paper trail of all the decisions they participated in, and that'll help protect you if one of these active investors decides to become the so-called disgruntled investor later down the road and want their money back, and you've already spent it. So, and that can happen. But that's sort of the discussion of active investor. Passive investors are not active investors. This is the definition of active investors, so you know that. Now, next slide. How do we go about finding these active investors? They're difficult to find. There are not too many of them around. They sometimes interfere with your creative vision, so there's a practical reason for not wanting active investors. The practical reason for wanting them is it makes it easier if you could get just 2 or 3 people or one person or 2 people to finance your film. That helps a lot, but it just doesn't happen that often. I mean, I've had a lot of times where producers come to me and say, well, we know somebody who could finance this entire film. Great. It just never happens. And so these people, these active investors, as we said earlier, have to have knowledge and experience in the industry, and they're not really in the film industry currently. So you're not looking in the film industry, you're looking outside the film industry for active investors. People currently, and you know this to be true, people currently working in the film industry tend not to be investors. Instead, they tend to acquire rights, and then they fire you. I've seen that happen. Or they say, well, we're not interested in your project right now. And 2 years later, you see something very similar on the screen. I've seen that happen too. Well, but maybe these people worked in the past in the film industry. That's how they got their knowledge and experience, but they're not in the film industry anymore. So, but problem is that most people who know anything about the film industry know that independent film is a very risky investment, and so you're not likely to see a lot of people who have knowledge and experience in the film industry want to be active investors in such projects. Now, another thing to consider, if you get too many active investors, you start getting 4, 5, 6, 7, 8 or more, it's likely that one or more of them are not going to qualify as active investors. Therefore, you're raising money from passive investors. Therefore, you're selling a security. Okay, so that's that's the distinction between active and passive. Next slide. If you decide to take the securities route, here's some thinking about that. You're recognizing that the active investment presents some problems. We've talked about that. You're embracing the advantages of securities offering. It allows you, the producer, to spread the risk amongst a larger group of investors. Passive investors do not participate in the decision making. That's a big advantage. Active investors might want you to have their daughter or their wife or somebody else starring in the film, and that can wreck a project. The passive investors, though, do not interfere with your creative vision. Another big advantage. But you do need to comply with the securities laws, and that's what scares a lot of independent producers off. So that's why I'm doing this YouTube video, so you'll have a better feel for what's involved. If you go the securities route, you got to comply with securities laws. So let's talk about what we need to do to comply. securities laws. And before we actually get into compliance, let's talk about choice of investment vehicle. Now, some people may say, well, let's do a joint venture. Joint ventures are usually for a couple of companies that come together to engage in a common enterprise, as how a decision said. Um, but that is for a specific vehicle for active investors. So all your investors have to qualify under that definition that we talked about earlier that the federal courts have provided for us. So that's not really what we're talking about today. Other producers have come to me at times and said, okay, well, I think I'm going to use a promissory note because they believe promissory notes were not securities. And so I looked into that question and ended up writing another article for Los Angeles Lawyer Magazine, basically saying that the only promissory notes that are not securities are the short-term commercial loans. Short-term commercial loans. And a film investment is clearly not a short-term commercial loan. So most promissory notes, if you use that method, will not avoid the need to comply with securities laws. Now, in the old days, when I first started doing this work, we used the limited partnership as the investment vehicle. You'd have limited partners and a general partner. Now, the reason we don't do that anymore is because we turn to the manager managed LLC, is because the manager managed LLC offers a limited liability protection to the manager and the members, which is what the investors are called in a manager managed LLC, as opposed to a limited partnership that does not offer limited liability protection to the general partner, only to the limited partners. So over the years, since the LLC came into use, we have started relying on it primarily. So most of these offerings today are manager managed LLCs. Now understand that there are two different kinds of LLCs. You have member managed LLCs, that's for active investors. If you had 3 or 4 people who qualify as active investors and you were willing to let them participate in the decision making and you wanted to work with them and they weren't being, imposing demands on you that were unreasonable, maybe that would work. And maybe you could find some people that comply. But if they don't qualify, then you're taking a chance. You're basically saying, I'm not complying with securities laws because I think I've got active investors when you may not actually have active investors. So you have to be careful about that. Now, so today the investment vehicle typically is the manager managed LLC. So next we need to draw a distinction between public and private offerings. Kind of the first rule of security is that you need to register your offering with the SEC at the federal level and with each state securities regulatory authority in each state where you plan to sell units in this manager managed LLC. But that's a public offering, and it's much too complicated, time consuming, and expensive for low budget independent filmmakers. So very few have tried that. As far as I know, only 3 public offerings of independent films have been attempted in the last 30 years or so, and none of them succeeded. Okay. So the general rule is to register your offering. The exceptions is what is typically used with independent film. And these exceptions are called exemptions. These are private offering exemptions. And so there are several choices that we need to make, and you need to be aware of these choices. And some of these, one of these, 506C down here, I'm pointing with my finger. 506C is relatively new in the last, 6, 7 years, whereas 506B has been around since 1992. But so choice number 1, Regulation D, Rule 5. These are SEC regulations. SEC Regulation D, Rule 506B. Okay. Now some people think, you'll hear this in Hollywood. Some people say, well, I'm doing an exempt offering, so there are no rules. So we're exempt from rules. No, that's not the case. You're exempt from the registration requirement, but you still have a set of rules, just a different set of rules, slightly different, but similar to a public offering. Some of the same kind of information is in your disclosure document. But anyway, so Regulation D, this is an SEC regulation, Regulation D, Rule 506B. Okay. It basically allows you to raise up to money from up to 35 non-accredited investors, unlimited accredited investors, the wealthy investors. But you and others associated with you have to have a pre-existing relationship with those prospective investors. In other words, you needed to have known them prior to the start of your offering and know whether this kind of investment is suitable for them. That's kind of the gist of Regulation D, Rule 506B. So if you're doing a small offering, like Judson Lynn's first offering, $120,000, and you know the people you're raising the money from, 506B would probably be the appropriate exemption. But if you're raising a significantly larger amount and you don't necessarily know enough people, you don't have the pre-existing relationship that 506B requires, then you might opt for Regulation D, Rule 506C. Again, SEC, Regulation D, Rule 506C. This exemption from the registration requirement allows you to raise money from accredited investors only, unlimited amount of money, unlimited accredited investors. Now, just so you'll know, accredited investors, there are about 8 different definitions, but the two that most commonly come into play is annual income, which is $200,000 a year, or $300,000 with spouse, or net worth, which is $1 million exclusive of primary residence. So that's what accredited investors typically are. No pre-existing relationship required. That's a big advantage of 506C. And you can advertise and conduct a general solicitation, which is another way of saying that there's no pre-existing relationship requirement. But one of the things you have to do with 506C that you don't with 506B is you have to confirm the status of the accredited investors. You have to have some documentation of their status as accredited investors, wealthy investors. All right, so there are more details in each of these, and there are chapters on each of these in the book Investor Financing Independent Film, so you can go there for more detail. The next possibility is regulation crowdfunding. The SEC decided to kind of get in on the crowdfunding deal. But these are investments, not donation crowdfunding. So be sure and understand the difference. These are securities. It's designed for small investors. The idea was to attract small investors to these kind of investments. But the SEC, I think, kind of messed up with this. They just required too many filings. They wanted to know who's doing what and when, and so they require what we call notice filings, or just some kind of filing prior to the start of the offering, during the offering, and after the offering. And it's just too burdensome, I think, because you can accomplish the same thing with 506B if you want small investors. So there's I don't get many clients who come in and say, well, I want to do regulation crowdfunding. Or if they do, I give them I say the same thing I just told you, and they say, okay, let's do 506B or 506C. Now, another point to be made is that all three of these regulations, SEC regulations, preempt state law. So before these laws were implemented, you would have to comply with the rules of state, whatever state you're going in, and also comply with the federal. Now it's just the federal, and that's also what allows me to work with people all over the country, no matter which state you're in. Okay, so now let's move and talk about what is in a security disclosure document. First, let's discuss terminology. I love terminology because I wrote the book about Dictionary of Film Finance and Distribution. But there are three different kinds of, or three different terminology or terms that are used in the securities business or industry. Prospectus is a term you've heard, and people use that, but it's associated exclusively with public registered offerings, which we said you're probably not going to do because they're too time-consuming, complex, and expensive. So if somebody comes to you and says, well, I want you to read my prospectus, and it's not a public offering, they haven't registered with the SEC, well, then they don't have the terminology right. The next one is the private placement offering memorandum. That is the name we use for a security disclosure document associated with Regulation D, any of the two Regulation Ds, 506B, 506C. On the other hand, the regulation crowdfunding, and I'm blocking the word regulation here with my picture, they use, in their terminology, just securities disclosure document. So that's just something that you should know as you go along. Now, when we say disclosure, we're talking about what you put in writing and give to each prospective investor before they invest. That's the whole idea here is you put together some information and give it to the prospective investor, and they get a chance to look at it, read it, and ask you questions, and then invest. Okay, that's the order of things. So let's talk about what kind of film-related information becomes the contents of the PPM, private placement offering memorandum, or securities disclosure document. Uh, and here's part of the list. And this is not everything. There are a few other things. And then there's a whole bunch of legal stuff that goes in addition to the film related contents. But here it is: title, screenplay of the film, date, number of script registration with the U.S. Copyright Office, screenwriter's name and bio, descriptive phrase regarding the film's genre and logline, anticipated MPA rating, screenplay synopsis, target audience analysis, planned shooting locations, budget, top sheet, estimated use of proceeds. Now, understand that when you send to some security attorney like me a budget top sheet, that's not the total of the offering proceeds. That's the production cost. Okay, the grand total for the production only. After that, down below that, in this presentation, in your disclosure document, we'll have offering expenses, which is not a production cost, and we might have some money put in there for marketing to distributors and going to film festivals, things like that. And we might also have a little money for maintaining the LLC, hiring an accountant to prepare the K-1s to give to the investors every year. And so in securities terms, we call this budget information, we call it estimated use of proceeds. In other words, you're explaining to your prospective investors how you plan to use their money. And you've got two columns, a minimum and a maximum, because we normally do these offerings as mini-maxi offerings. And they both add up to in the round numbers of your minimum offering proceeds and your maximum offering proceeds. And that's what it's called in securities terminology. It's not budget, it's estimated use of proceeds. Then also another possibility is box office comparables, and we can have a whole discussion about that, what's appropriate, what's not appropriate, and how the professional proprietary preparers of, of box office comparables, how they kind of fall short in many cases of doing what the SEC wants you to do. So the next slide, we're going to continue with our disclosure. Okay, now we're continuing our disclosures in a PPM for a film offering, and we're moving from the information about the film itself to the rest of the legal matters are relating to the entity and the nature of the investment vehicle, things like that. Choice of entity, of course, that we've already discussed. That's most likely going to be manager managed LLC these days. We've already talked about that. The name of the investment vehicle, name of the management LLC. I like to include the phrase film production in there. So we take normally the title of the script plus film production LLC. That way the investors know exactly what they're investing in just looking at the title. Don't have to do that, but that's just my preference. The name of the management entity, that is the manager. Usually better to have a company than an individual. Investors tend not to like to write checks to individuals. So, but it doesn't have to be an LLC or a corporation. It can be a DBA, so-called, as they say in California, fictitious name company. You'll also want to include the date and state of creation of that company, who owns it, and we have to do some disclosures relating to the owners and their compensation. Address and phone the narrative biographies of the key people that are committed to the project, and that's really important because investors look at that. What you're trying to do is gather together a group of filmmakers who have specific skills and who've worked on films, hopefully recognizable films in the past, to reassure the investors that you've gathered a group of filmmakers that can make a film. And then the minimum and maximum amount of the offering proceeds, including offering expenses. So a lot of filmmakers just stop when they finish, they do their budget work and they say, okay, this is what it's going to cost to produce a film. But there's something called offering expenses, or what it costs to put this offering together and so forth. And then also possibly marketing to distributors and some money for LLC management, paying an accountant to prepare K-1s each year to provide information about their investment to the investors. And then the number of investment units and price of each. This is an arbitrary determination. You look at your minimum offering proceeds, your maximum offering proceeds, and you're deciding whether or not you want the unit price to be. It needs to be some round number that's evenly divisible into the minimum and maximum offering amounts. And so you would pick a number like 10,000 or 25,000 or 50,000, 100,000, depending on what you're comfortable asking people for, what you think they can afford. And you divide that unit price into the minimum and the maximum, and that tells you how many units you're offering. We may also build in some incentives to encourage investors to purchase more than a single unit, multiple units. And then we get to the revenue sharing ratio between the producer management group, the manager, and the investor group. Typically, what we see these days is 80, 90, 100% of the LLC distributable cash, which is a defined term in the LLC operating agreement, will flow to the investor group first, and they share pro rata amongst themselves based on the number of units each has. And then they until they arrive at recoupment, and recoupment is defined as either 120% or 125% of the original investment. Then it switches to 50-50. The ratio switches to 50-50 between the manager and the investor group. That's typically the film-related information that's disclosed. There is other information that you see in a PPM that's more of a legalistic nature, and we won't go through all of that now. Okay, next slide. Okay, now this slide is an attempt to explain why I think a lot of people in the film industry in particular make the argument that there is no need for a PPM, no need for a disclosure document. And that is that there is language in Regulatory Rule 506C that says no specific disclosures are required. Okay, so yeah, that sounds pretty good. But these people have failed to read the preface to Regulation D, or the introduction to Regulation D, which says that Regulation D transactions, that includes 506B and 506C, these transactions are not exempt from the SEC's anti-fraud rule. And that rule is 10b-5, Rule 10b-5. And you can look it up. And basically, that rule says you cannot employ a device or scheme to defraud or engage in manipulative acts. You cannot make untrue statements of a material fact or omit a material fact. And you cannot make misleading statements. So again, some people, really smart people, think this means that it's safer to not do anything, to not provide any disclosures at all. I disagree with that. Okay, we'll move to the next slide. Of course, that raises another question. What is a material fact? A material fact is one that a reasonable investor would consider important. Again, kind of vague, and people can argue back and forth about what's important, but You just have to stop and think, okay, what would investors want to know about this opportunity to invest in an independent film that might, that I should consider? So what a reasonable investor would consider important. Issuers, and the issuer in these cases, is the manager managed LLC. Issuers are obligated to provide such further material information, important information, if any, as may be necessary to make the information required under Regulation D not misleading. Now, this is kind of a word salad, and I fault the SEC for not being more clear about this, but that's some of the language that they're using. Issuers are obligated to provide such further material information, if any, as may be necessary to make the information required under Regulation D not misleading. Okay. So now we're going to add something to that in the next slide. Now, here's what I think is the better position or the safer interpretation. And basically, you have a choice here to either go the risky route or the safe route. I, of course, would opt for the safe route on behalf of my clients because otherwise, I mean, the people who are giving you the advice don't disclose anything basically are threatening to ruin your career, or they could possibly ruin your career if you follow that advice. But here's what I think is a safer interpretation of Reg D Rule 506C and your disclosure obligations, considering that Rule 10b-5 applies to all Reg D transactions. You should disclose all material aspects of the transaction. In other words, everything that's important, everything that a reasonable investor would consider to be important, you should put it out there, put it in writing, and show it to them. Second thing, don't leave anything out. That's important. Okay. Don't leave it out. Don't omit anything that's material. And then the third, don't disclose anything that is misleading. So we don't want to be misleading the investor because that can come back and haunt you. And so basically, this document, yes, it's a selling document to some extent, but it's also a document that's going to protect the producer. Because if a disgruntled investor goes to an attorney and says, I gave this filmmaker $50,000, want my money back, I don't like what they're doing, or whatever reason, then all you have to do is point to the PPM and say, well, it says right here you could lose all your money, and here are the risk factors that are disclosed and so forth. And so this is what I think is a safer interpretation with respect to disclosure relating to Reg D 506C. And I think a lot of people get that wrong, and they can get you in trouble by being wrong. And that is financial projections. Now, I'm going to tell you this little story real quick. One time I used to be really active on the lecture circuit all over the country, particularly in Los Angeles when I was there for that 23 years. And one time I was on a three-member panel discussion before the Beverly Hills Bar Association. All the entertainment attorneys in the Los Angeles area tend to belong to the Beverly Hills Bar Association. So I'm up there, and I'm sitting in the middle, and on my right is a securities enforcement attorney for the SEC. Actually worked for the SEC. On my left was a prominent entertainment attorney, somebody who does a lot bigger deals than I do, and is quite the expert in entertainment law, but not too much of a background in securities law. And so somebody in the audience stood up at one point and says, well, what about financial projections? Should we include financial projections with our offering? And the entertainment attorney on my left has a tendency to get excited, be quite animated. And he jumped up and said, no, don't do financial projections. You'll be sued. Well, I'm sitting there, and I've done hundreds of these offerings, and probably most of them had financial projections, and nobody's been sued. So should I try not to embarrass my colleague, or should I be honest and tell the attorneys assembled out there, all these entertainment attorneys, what my experience is? Well, if you know me, I opted for the latter. And so I explained, said, look, the SEC, and this is something most people don't know, the SEC has a policy about financial projections. They've got their own policy. You can look it up, read it. And it basically says, look, financial projections are not required by law. They're not required. You can do a film offering without financial projections, but they are encouraged by the SEC. Okay. And investors, this is my opinion, and based on my experience, investors like to see financial projections. After all, this is a financial investment. So they'd like to see, well, how much money is it possible to make, or what's likely, or what do you think? And so the SEC policy comes in and they say, look, as long as you disclose, again, put in writing and give to these prospective investors before they invest, the underlying assumptions, you put those in writing. And these assumptions are reasonable. And you use plain English, avoid industry jargon. So not because investor understanding is really the goal. Those are the three elements of the SEC policy. Then you've complied with the law. Okay. So let's clarify what assumptions are. Okay. When I help my clients do projections, I'll have maybe 20, 21 assumptions. And we start off like this. We say, okay, we are assuming for purposes of preparing these financial projections that we raised this amount of money. That's an assumption. Somewhere between the minimum and the offering minimum and the offering maximum, we're going to pick a number and say, okay, we're going to assume, because this hasn't happened yet. We're going to assume that we raised this amount of money. We're going to assume, for purposes of preparing these financial projections, that we completed the film. We're going to assume that the film was of a quality to be of interest to distributors. We're going to assume that we actually made a distribution deal. We're going to further assume that this distribution deal allowed us to receive, the LLC to receive 50% of the film's net profits. Those are all assumptions. If they're reasonable, they meet the legal standard. Okay. And then you just continue on with those assumptions, all the assumptions that might affect the amount of money that's coming back in this revenue stream for this film, and then you do the numbers. You calculate the numbers. You've got these items over here in terms of revenue sources and then expenditures, and you figure out what those numbers will be and what the return on investment is in a percentage. So be aware that the SEC has a policy. If you follow the SEC policy and your assumptions are reasonable, you state your assumptions in writing, you've complied with the SEC policy. So another item that's important people need to be aware of is there's something called notice filings that usually in most states, there used to be a couple of states that, like New York, maybe might have been Connecticut, that required you to do a notice filing before you even started your offering. Well, I think most of that's gone by the wayside. You have to check. But notice filings are basically a way to notify a specific jurisdiction, like a state or the federal government, the SEC, that you're selling security in their jurisdiction to their citizens. And if they need to find you for any reason, need to get in touch with you for any reason, this is where you can be contacted. It's usually done on something called a Form D. The SEC has its own form. You can go online and download a Form D, and you can go online and download Regulation D for that matter. Excellent late night reading. So there are federal and state notice filings. Now, I said earlier that Regulation D, 506B and 506C preempt state law, except for the state notice filing requirement. The states still want to know that you're selling security in their state, and if they have a disgruntled investor who complains to them for any reason, they want to find you, they need to talk to you, they'll know where to find you. And as I say, this notice filing is usually done on the SEC's Reg D, or on Form D, and those are available online. Now, today, and this hasn't always been the case, we used to fill out these Form Ds manually and send them in, but now it's an electronic filing requirement, and it's much more complicated. So my recommendation to all of my clients and to you is that you should take advantage of these Form D filing services that have cropped up since this law changed and the electronic filings are required. So there are services that you can call, and pay them a modest fee, $150, something like that, and they'll handle the Form D filing for the SEC. Some of them may also handle the state filings, and I try to find one to do both, get it all done. So, and usually these filings are required about within 15 days of the first sale in the offering. Okay. Uh, so I would recommend you use these filing services. Now, let's talk briefly about the failure to comply. What are the consequences? Uh, any investor can become a disgruntled investor and doesn't have to have anything to do with you or the film. They can just be in a bind financially and want their money back because looking back on it, they thought, well, that was a foolish investment. And they can complain to the SEC. They can complain to the state securities regulatory authority in their state. They can go to an attorney and try to instigate litigation. And so there are three different ways. Those guys that I was talking about earlier that ended up going to prison, a disgruntled investor in Alabama complained to the Alabama Securities Board or whatever it's called there, and that ended up in federal litigation, or and three of them were convicted of securities fraud. So what are the elements of securities fraud? Well, there's deception, intent, reliance, and loss. The producer, in this case, we're talking about film, made deliberate misstatements or they hid important facts. Again, this is materiality. Okay, it's important. The perpetrator, which is the producer, must have intended to deceive investors. You have to show that in court, or the prosecutor would. The investor must have relied on that false statement, and that reliance must have caused financial harm. That's what securities fraud is. Okay. Now we get to the consequences. The SEC might handle the civil side of it. The FBI would investigate the criminal side of it. The state authorities would investigate and prosecute at the state level. And did I say prison? Yes. Again, the Los Angeles Lawyer article talks about these three guys who raised money for a film and put most of it in their pocket, never made the film, ended up being convicted of securities fraud, two of which ended up in prison. Now that article is just a slice in time when it was written, but you can update the enforcement research by simply going to the archives of the SEC, the enforcement archives of the SEC, or the enforcement archives of any of the state securities regulatory authorities. The article covers not only that one case, but some cases, similar cases in California, Texas, and New York, maybe Florida. But you can update that research and check your own state. See, just go to the archives and put the word film in there, or independent film or films, and a listing will come up if they're very active. I was a little surprised myself about that. Be aware that in some civil cases, the investors could seek treble and be awarded treble damages or punitive damages in multiples of actual damages. So it's a pretty serious matter. I mean, it could destroy your career. So I don't recommend it. I recommend that you comply with the law. And in my view, the law requires you to disclose all material aspects of the transaction. Don't leave anything out that's important, and don't say anything that's misleading. Simple as that. Okay. Now, we're almost to the end, folks. And one of the points I'm trying to make here is be careful from whom you get your information. That's how all this started. The impetus for me putting this information online. You, as a producer, are responsible for vetting everybody that you're bringing in to help you produce this film, including the securities attorney on the front end, one of the early hires you make. You want to check them out thoroughly, okay? And if they don't know the difference between a prospectus and a PPM, or Reg D 506B and 506C, or have never done this before, you may be making a mistake by hiring somebody like that. And that's the producer's responsibility. And one of the things we like to say in law is, if there's no citation, no credibility. That's a little bit of an exaggeration because you can still have some credibility if you don't give citations, if your information is accurate. But if you've got inaccurate information and no citations, no credibility. Um, and so I encourage you to recognize when you're selling a security and to make a good faith effort to comply with securities laws. And I think you'll be in good shape. My contact information again is there. I'm happy to talk to you, answer whatever questions you have. Check out my website. I've got a lot of articles there and a lot of useful information. And so I hope this has been helpful to you. Again, I look forward to hearing from you. Thanks, Mike.